Hey y'all, so I'll probably get in trouble for this one, but I am just offering information that I find on the internet. How true this is, how credible it is. It's been since dismissed. I'm just offering information. When there is a lack of transparency and information on certain items, that's where conspiracy theories come in. Anyway, so it says in the United States District Court, Southern District of New York, Jane Doe proceeding under a pseudonym. I think they say that her name was supposed to be like Katie Johnson, whatever. Plaintiff versus Donald J. Trump and Jeffrey E. Epstein. I've seen like this first page like floating around social media. I didn't know what it was, but you know, since there's all this crazy stuff going on, I'm just offering information. Okay. So case number and then jury trial demanded. It says complaint for rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and defamation. Okay, so plaintiff Jane Doe, proceeding under a pseudonym, brings this action against Donald J. Trump and Jeffrey E. Epstein and alleges that parties, one, plaintiff is an individual residing in and a citizen of the state of California. Two, upon information and belief, defendants Donald J. Trump and Jeffrey E. Epstein each reside in this district and are citizens of the state of New York. Jurisdiction and venue. Three, plaintiff is a citizen of the state of California for purposes of diversity. Jurisdiction under 28 USC subsection 1332. Again, I found this online. I'm not saying that he did it. I'm not saying he didn't do it. But if he did, we need to have charges. I'm just saying. So don't get mad at me. Okay, so four defendants are citizens of the state of New York for purposes of diversity jurisdiction under 28 USC subsection 1332. Five, this court has original subject matter jurisdiction with respect to this action pursuant to 28 USC subsection 1332 as there exists complete diversity of citizenship for plaintiff and defendants and the amount in controversy exceeds $75,000, exclusive of interest and costs. Defendants are each subject to the jurisdiction of this court pursuant to 28 USC subsection 1332 with proper venue pursuant to 28 USC subsection 1391 as both defendants are residents and or domiciled in this district in the events giving rise to the claims occurred in this district. It says rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, and false imprisonment. A plaintiff was subject to acts of rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and threats of death and or serious bodily injury by the defendants that took place at several parties during the summer months of 1994. This case has since been dismissed. So if all those things actually happens, why? Okay, the parties were held by defendant Epstein at a New York City residence that was being used by defendant Epstein at 9 East 71st Street in Manhattan. During this period, plaintiff was a minor of age 13 and was legally incapable under New York law of consenting to sexual intercourse and other sexual acts detailed herein. New York Penal Code L subsection 130.053A. The rapes in the first, second, and third degrees, sexual misconduct, criminal sexual acts in the first, second, and third degrees, sexual abuse in the first, second, and third degrees, and forcible touching, and on information or belief, predatory sexual assault. Detailed herein are unlawful under New York law, e.g., New York Penal L subsection 130.20 through 130.52 and 130.55 through 130.65, and on information and belief 130.95, and constitutes the torts of inter alia. I don't know what that is. Not an attorney. Assault, battery, false imprisonment, and intentional or reckless infliction of emotional distress, including threats of force and serious bodily harm under New York law. In addition, 18 U.S. Code subsection 2255 provides plaintiff with a civil remedy for personal injuries because plaintiff, while a minor, was a victim of violations of 18 U.S.C. subsection 1591, 2421, 2422, B, 2423, A, and she suffered personal injury as a result of such violations. Declaration of Plaintiff Jane Doe, Exhibit A here too. Declaration of Tiffany Doe. Exhibit B here too. Declaration of Jane Doe. Exhibit C here too. Jane Doe, Tiffany Doe, and Joan Doe are each pseudonyms as each woman wishes anonymity. Tiffany Doe, a witness, was an employee of defendant Epstein. Exhibit B. Joan Doe, a witness, was a childhood classmate of plaintiff who in the 1994 to 1995 school year was told by a plaintiff that plaintiff was subject to sexual contact by the defendants at parties in New York City during the summer of 1994. Exhibit C. Courts have discretion to allow proceeding anonymously where the need for privacy outweighs the public's interest in knowing their identity and any prejudice to the defendants. Sealed plaintiff versus sealed defendant, 537 F3D 185 189. I don't know, I guess circa 2008 maybe. And this litigation involves matters that are highly sensitive and of a personal nature, and identification of plaintiff would pose a risk of retaliatory physical harm to her and to others. Exhibit A, all of the 10 factors that the Second Circuit articulated as relevant to this analysis favor anonymity, especially factors 1 through 4, 7, and 10, e.g., factors 1 and 2, where the litigation involves matters that are highly sensitive and of a personal nature, and whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties, or are neutral with respect to anonymity. Protecting plaintiffs' anonymity is also appropriate as she is a rape victim. Plaintiff was enticed by promises of money and a modeling career to attend a series of parties with other similarly situated minor females held at a New York City residence that was being used by defendant Jeffrey Epstein. At least 4 of the parties were attended by defendant Trump. Exhibits A and B. On information and belief, by this time in 1994, defendant Trump had known defendant Epstein for 7 years. New York, 10/28/02. I've known Jeff for 15 years. He's a terrific guy. Trump booms from a speakerphone. He's a lot of fun to be with. It is even said that he likes beautiful women as much as I do, and many of them were on the younger side. No doubt about it, Jeffrey enjoys his social life and knew that plaintiff was then just 13 years old. Exhibits A and B. Defendant Trump initiated sexual contact with plaintiff at 4 different parties. On the 4th and final sexual encounter with Donald Trump, defendant Trump tied plaintiff to a bed, exposed himself to plaintiff, and then proceeded to forcibly rape plaintiff. During the course of this savage sexual attack, plaintiff loudly pleaded with defendant Trump to stop, but with no effect. Defendant Trump responded to plaintiff's pleas by violently striking plaintiff in the face with his open palm and screaming that he would do whatever he wanted. Exhibits A and B. Immediately following this rape, defendant Trump threatened plaintiff that were she ever to reveal any of the details of sexual and physical abuse of her by defendant Trump, plaintiff and her family would be physically harmed if not killed. Exhibit A and B. Defendant Epstein had sexual contact with plaintiff at two of the parties. A second sexual encounter with defendant Epstein took place after plaintiff had been raped by defendant Trump. Defendant Epstein forced himself upon plaintiff and proceeded to rape her anally and vaginally despite her loud pleas to stop. Defendant Epstein then attempted to strike plaintiff about the head with his closed fist while he angrily screamed at plaintiff that he, defendant Epstein, rather than defendant Trump, should have been the one who took plaintiff's virginity. Oh my God. Sorry, this is gross. Before plaintiff finally managed to break away from defendant Epstein, exhibits A and B. See, and that's where you just don't know what the hell to believe. You really don't. I mean, this just like a salacious, rag of a lawsuit. But then if it's true, then why was nothing done? I don't care who the hell they are. But is that just all part of the damn deep state cover up kind of stuff? If you have money, you just get away with anything? I don't know. I'm just putting this out there. I didn't write this crap. I'm just putting out what I pulled up online because I'd seen something about this before. And I've had other people say stuff about it. So I'm like, okay, well, let me look into it. Just like I've looked in a lot of other stuff. So this isn't the first document I pulled up and read. I'm reading what the court filing is, even though it's been dismissed. I mean, I don't know. I'm just putting it out there. So the threats of violence against plaintiff and her family continued, this time from defendant Epstein, who again reiterated that plaintiff was not to reveal any of the details of his sexual and physical abuse of her or else. Specifically, plaintiff and her family would be seriously physically harmed if not killed, exhibits A and B. While still under threats of physical harm by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted, plaintiff, who has suffered from stress, emotional distress, mental pain, and suffering, among other problems ever since the assaults, was subject to daily painful reminders of the horrific acts of the perpetrators, defendant Trump, via mass media coverage of him starting on or about June 16, 2005, that over a short period of time became continuous and unavoidable. I don't know what mass media coverage of him. I guess just seeing him on TV, but we see people all the time that have TDS, so I'm not sure. Okay, as a direct and proximate result of the sexual assaults and rapes perpetrated by defendants under her, or upon her, plaintiff has suffered stress, emotional distress, and mental pain and suffering, as well as adverse physical consequences. As a direct and proximate result of the sexual assaults and rapes perpetrated by a defendant upon her, plaintiff has suffered physical pain and suffering. As a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has been subjected to public scorn, hatred, and ridicule, and has suffered threats against her life and physical safety. As a direct and proximate result of the sexual assault and the rapes perpetrated by defendants upon her, plaintiff has incurred special damages, including medical and legal expenses. The sexual assaults and rapes perpetrated by defendants upon plaintiff were intentional acts. The conduct of defendants demonstrates willful, reckless, and intentional conduct that raises a conscious indifference to consequences. At the appropriate time in this litigation, plaintiff shall amend her complaint to assert a claim for punitive damages against defendants in order to punish the defendants for their actions and deter defendants from repeating their conduct. Tolling of statute of limitations. Any statute of limitations applicable to rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, false imprisonment of a minor, if any, is told owing to the continuous and active duress imposed upon plaintiff by defendants that effectively rob plaintiff of her free will to commence legal actions until the present time. Cullen versus Morgiata, Ross versus the United States, and more particularly, the plaintiff was unrelentingly threatened by each defendant that were she ever to reveal any of the details of the sexual and physical abuse caused by or to her by defendants, plaintiff and her family will be physically harmed, if not killed. The duress is not terminated and the fear has not subsided. The duress is an element of or inherent in the underlying causes of action complained of herein. The duress and coercion exerted by defendants has been such as to have actually deprived plaintiff of her freedom of will to institute suit earlier in time, and it rose to such a level that a person of reasonable firmness in plaintiff's situation would have been unable to resist exhibits A and B. Both defendants let plaintiff know that each was a very wealthy, powerful man and indicated that they had the power, ability, and means to carry out their threats. Indeed, defendant Trump stated that plaintiff shouldn't ever say anything if she didn't want to disappear like Maria, a 12-year-old female that was forced to be involved in the third incident with defendant Trump, and that plaintiff had not been seen since that third incident, and that he was capable of having her whole family killed, exhibits A and B. The duress had prevented plaintiff from starting litigation about this year or before this year. However, as soon as she surfaced, she received threats. More specifically, shortly after her first complaint was filed in California on April 26, 2016, how convenient, she started receiving threatening phone calls on her cell phone, exhibit A. Defendants are equitably stopped from arguing that any statute of limitations has not been told, as defendants wrongfully forced plaintiff to refrain from timely commencing this action by threats, duress, and other misconduct, exhibits A and B. Zimmerman versus Polyprep Country Day School, General Stencils Inc. versus Chippa, and then 1966, a wrongdoer should not be able to take refuge behind the shield of his own wrongdoing. Moreover, this action has been brought before the facts giving rise to the estoppel have ceased to be operational, i.e., while still under threats of physical harm, by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted. And since plaintiff has decided to seek redress at this time, plaintiff seeks an order of protection in favor of plaintiff and all associated with her so as to protect them from harm or harassment from defendants and their agents and associates, exhibit A. Defamation. On information and belief on or about April 28, 2016, defendant Trump provided the following statement to American Media, Inc. and or Radar Online LLC for publication on at least their website, radaronline.com, regarding plaintiff's complaint, EDCV 16797-DMG and the KSX, whatever that is, filed in the United States District Court for the Central District of California. The allegations are not only categorically false, but disgusting at the highest level and clearly framed to solicit media attention, or perhaps are simply politically motivated. There's absolutely no merit to these allegations, period. Let me just stop right here. So we see that the Russia collusion hoax was actually like a hoax perpetrated, at least this is what we're being told from the director of national intelligence. So obviously she's got all the memos and documents and emails of whatever they had left over, that it was just a hit job, like the Steele dossier and all the other stuff. So this, because it came out in 2016, could very well be a way to try to hurt his presidency or potential presidency, along with every other damn smear that they've done on him. I'm not defending him, because if he did something wrong, he should be held accountable just like any other person. But if he didn't do anything wrong, then he needed to be, you know, people need to apologize for the crap they've done to him. I know there's TDS and there's like severe levels of TDS, but anyway. So let's see. The statement provided for publication by defendant Trump was published by said website and has been republished elsewhere in whole or in part numerous times, and similar statements of an attorney for defendant Trump were also published, including on September 22nd, 2016, by a courthouse news service. The statements provided for publication by defendant Trump and his agent and that were published by said websites are false as they pertain to the plaintiff. The published statements are libelous on their face and clearly expose plaintiff to hatred, contempt, ridicule, and obligate. I don't know, whatever. I don't know what that word is. I've never seen it before. Probably need a thesaurus, but I don't know, dictionary. Anyway, as a proximate result of the above described publications, plaintiff has suffered loss of her reputation, shame, mortification, and injury to her feelings, all to her damage in an amount to be established by proof at trial. The above described publications were not privileged because they were published by defendant Trump and his agent with malice, hatred, and ill will toward plaintiff and the desire to injure her. As a direct and proximate result of defendant Trump's defamation of plaintiff, plaintiff has been subjected to public scorn, hatred, and ridicule, and has suffered other injury. Prayer for relief. Wherefore, plaintiff prays for judgment against defendants and for the following relief: that judgment be entered against defendants for special damages, compensatory damages, and punitive damages in an amount which shall be shown to be reasonable and just by the evidence and in excess of $75,000, exclusive of interest and costs, that all costs of this action be assessed against defendants, including all reasonable attorney's fees, costs, and expenses for this action, that an order of protection in favor of plaintiff and all associated with her be issued so as to protect them from harm and harassment from defendants and their agents and associates, such other and further relief as the court may deem just and proper. And then jury demand, plaintiff demands a trial by jury of all issues for properly triable by jury in this action, and then dated September 30th, 2016. So anyway, I don't know. I'm just throwing stuff out there. Declaration in support of plaintiff's request for protective order. Okay, is it competent? 18 years old. Traveled by bus, New York. Okay. I mean, I'll put that. I'll try to get this in the actual, like the description. You can read through it if you like. But I mean, I'm just putting stuff out here because I'm just like, wow. There's several things here, but why would it be dismissed is all I'm asking. Like, let's see here. Let me go back. Oh, I got so many things open. So I did obviously ask my friend chat GPT about this. And pretty much the first suit was filed in April 2016 in California, was dismissed in May 2016. A second suit followed in June of 2016 in New York with detailed rape allegations. That suit was withdrawn in November 2016 after Jane Doe reportedly canceled a press conference amid threats, and then a third version was refiled in September 2016, but also dropped in November of 2016. So it says there was no, these were civil, not criminal filings. They did not proceed to trial. No legal findings or conviction was rendered. So while there was indeed a high profile allegation from someone referred to as Katie or Jane Doe claiming rape of a minor, it was part of a civil case that was dismissed or withdrawn and not a criminal indictment or conviction. So all I'm saying is that some of this stuff is like, come on. There was no criminal indictment. They didn't even bring it to court. They just wanted to file a civil lawsuit to get money from the deal. I don't know. I mean, you make up your own mind on this stuff. I'm just, like I say, putting information out there. So we've been lied to so much, and certain things have just been covered up for so long. But anyway, I'll talk to you later. Bye.